I now move to the cause of death. May I draw us to the provisions of Section 213 of the Penal Code, which is very long and which I've made a general reference to. And so it provides the circumstances under which the cause of death may be inferred and proved by way of circumstantial or medical evidence. And in that regard, allow me to draw your attention to the case of Benson Gunyi versus Republic and request that you look at it later. In support of the prosecution case as to what caused the death of the deceased, the prosecution called the doctor who performed a post-mortem on the body of the deceased. And this is what the doctor said, that he made an observation. It was a body of a female aged about 28 years. It was wrapped in a blood-stained wet maroon and white bed cover. Both hands and right leg had henna tattoos and sealing straps. On examining the body externally, he noted that there was an irregular, invasive wound, interior neck, measuring 7 by 6 centimeters, with visibly slit trachea and airway. That there was blood oozing from the nostrils. The body was pale, an indication it was lacking blood. He saw contusions on both wrists and bruises around the wrist of both legs. Internal examination revealed that the airway had been shot through and through. The trachea had been transected at the level of thyroid glands, and the right carotid artery on the neck and right jugular vein had been severed. The doctor says that means cut through and through, and there was blood oozing from her private parts. So the doctor formed the opinion that the cause of death was exsanguination due to severe neck injury due to sharp force trauma, and that the probable weapon used was a sharp object. So based on this evidence of the doctor, it is the finding of this court that the prosecution have proved that the cause of death of the deceased. Okay? The third element I am addressing is whether that death was lawful or unlawful. Article 26, sub-article 3 of the Constitution of Kenya states that, a person shall not be deprived of life intentionally except to the extent authorized by the Constitution or the written law. We all know that if a death sentence is applicable and the court makes an order that you go and suffer death, yes, you are entitled to your life, but once the court makes a finding, then you fall under this provision as an exception. So the question one would be asking is, now that we have established the death occurred, and what caused it, then was that death lawful? In addition to, say, Article 26, may I draw your attention to the case of Busambizi Wesonga versus Republic 1948, where the court said this: every homicide is presumed to be unlawful except where circumstances make it excusable or where it has been authorized by the law. For homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or defense of property. Pursuant to these provisions and in my own understanding, I find that excusable homicides are killings which result from accident or inadvertence or done up by a person who lacks capacity to commit an offense, such as a young child or a person who is legally insane or in any reasonable defense to self or property. In the instant matter, Dr. Njenga did not testify to any circumstances that would amount to excusable homicide. In cross-examination of the doctor by the defense counsel, he stated that there was no evidence of strangulation, nor a gun or bullet wound, and there was nothing unusual in the pancreas, indicating that the blood that was oozing from the nostrils was because the throat was slit at the level of the thyroid glands, and clarified that the wound would not have been inflicted after the death because a person does not bleed after death, as it is the heart that causes the bleeding. Pursuant to the evidence of this doctor, it is the finding of this court that the deceased did not die of an accidental or natural cause. The death was not accidental, it was not an unnatural death. Therefore, this is a clear case of homicide that falls outside the excusable homicides. And so, the finding of this court that the prosecution have proved that the death was unlawful. We are still on our ingredients of the charge. And so the next issue to determine is whether each or both of the accused persons are the ones who caused the death of the deceased. And then finally we'll be answering a question: if they did they have malice aforethought? Because you can cause a death, but you didn't have malice aforethought, and of course that may be manslaughter. We are dealing with death. So they need not just to prove that they committed the offense, but there was malice aforethought. I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person for ease of understanding and flow of the judgment. And so right now I'm analyzing the evidence the prosecution have adduced in answer to the question as whether the first accused person caused the death or killed, bluntly put, the deceased. Under this particular issue, I have discussed several items just for understanding of the parties. And let me just mention some of the items that fall under this. There is the issue of identification parade. There is the issue of the cloth which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner, again for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nando treated me to good substance, not good in the sense that none of the other people have substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages of 35 pages is really a summary of what the parties submitted, okay? But I would like to read it out in brief for us to move. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following, that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth, changed into those clothes, went to the deceased house, committed the murder, changed out of those clothes, and that's it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her to submit before the murder or in the course of the murder. It is the submission of the prosecution case that after the accused person, that is the first accused person, had committed the offense, he went and destroyed the cloth, which would have been used as evidence in this case. It is the prosecution case. He then shot himself to divert the attention of the investigators from investigating the murder charge to investigating a shooting incident. The family of the deceased concurs and associates themselves with the prosecution case and invites this court to note that the evidence by the first accused person that he did not know the deceased is insincere. And they draw the court's attention to the fact that there is call data that speaks to the contrary. And the family of the victim submitted to this court that it should take cognizance of the fact that motive is irrelevant for purposes of proof of the offense of murder. What did the first accused submit on? The first accused persons have submitted that the description given by the prosecution witnesses on the clothes that the first accused was wearing is generic in the sense that those clothes did not have any marks that would identify them specifically out of any other clothes of the same kind. The first accused person has submitted that there was a lot of contradictions in the prosecution witnesses' testimonies. I have analyzed what they are inviting this court to consider as contradictions, and they are as follows. One, that there are contradictions on the time when Harun entered the deceased house and left. And that saying those contradictions arise from the record held by the protected witness number 3, the guard at the gate, that shows that Harun entered the deceased house at 23:21 and left at 23:31. And therefore that suspected killer was in the deceased house for only 10 minutes. And they are submitting, is it possible to commit a murder in 10 minutes of this kind? they have submitted that the person whom the court is being invited to deem as the first accused person and who has been identified as Haron is not the first accused person. That the prosecution have failed to show the nexus between Haron and the first accused person. They have invited this court to look at the contradictions as they relate to the evidence of the witness number 8, Jennings, that the first accused person had a bag in which he carried a white counsel when all other witnesses do not speak to a bag. They have invited this court to consider that the accused person has said he didn't know the deceased, and therefore there is no way he would have even known that he was coming from South Sudan. They have told this court to consider that when you look at the ID card of Becerra and you look at the accused person, there is no relationship. They have invited this court to take cognizance. May I request that you probably stop there for now? Thank you very much. I realize that I need the attention of the council, but they need water, so I hope you have water.
Thank you.
This court has been invited by the first accused person in his submissions to take note of the fact that there is a message that was sent to PW16 Kaka from the phone of the deceased person saying, "Kuja unisaidie kulala." And that if that message got to the deceased Sudanese boyfriend, he would have gotten infuriated, he would have gotten annoyed, and probably would commit the murder. This court has been invited to consider that the forensic evidence showed that other than whatever evidence the prosecution had brought, there were 2 other unknown male whose DNA was found on the strappings that were used to tie the deceased. And so the argument by the first accused person is that it is these 2 other male persons, they are known, that must have committed the crime. This court, I said the first defendants treated me to quite lengthy submissions, and I took all of them into consideration. This court has been invited to note that the allegations by Brian Kasaine Spira that he was called by the first accused person at 2 a.m., asked for paraffin to go and burn some items, is not true. This court has been invited by the first accused person to find that the shot that the prosecution produced in this court, having blood stains of the deceased and which has been attributed and said to belong to the first accused person, is not the shot which the police collected from the first accused house. That if the prosecution needed to prove beyond reasonable doubt that shot is the same shot they collected, they should have brought a photograph thereof. This court has been invited by the first accused person to make a finding that the identification process was flawed. This court has been invited by the first accused person to find that there was an intention by the investigators to fix the first accused person, and that is evidenced by capture of a wrong vehicle somewhere in Karioko to tie the evidence of a witness who said that the first accused person told him he stays in Italy. this court has been invited by the first accused person to make a finding that the evidence by Jennings PW8 that he drove the second accused person's vehicle is a lie, and that he had his own vehicle and at no time did he drive the second accused person's vehicle that was with the first accused. The court has been invited to make a finding that there was no blood stain at all on the shot that the deceased had, and which was, the first accused had, and which was collected from his house. The court has been invited to consider that the investigating officer did not investigate satisfactorily or adequately whether the deceased Sudanese boyfriend was in Kenya and could be a suspect. The court has been invited to note that other persons who were in the deceased house on the material night were never subjected to an identification parade. And so, in a nutshell, the court is being invited to make a finding that the prosecution have not discharged their burden of proving the case against the first accused person beyond reasonable doubt, and he should be given the benefit thereof. That this court do dismiss the case against him for lack of merit. So, having considered the evidence that I've spoken to and the submissions, I've raised the following issues for determination. 1, whether the first accused person knew the deceased prior to her death. Secondly, whether the first accused person stole and used the stolen identity card to access the Moria Gardens where the deceased was staying. Thirdly, whether the clothes that the first accused person was wearing on 19th of September 2018 implicates him in the commission of the offense. Fourth, whether the accused person was in the deceased house on 19th of September 2018, and whether he was the last person to be seen with the deceased. The fifth item, question. Whether the first accused person had a gun on the particular night and used it to subdue the deceased. The next issue I'll be looking at is whether the first accused person was positively identified on the identification parade. And lastly, but of course not the least but very important, a recap of whether then the prosecution have given this court adequate evidence to make a finding that the first accused murdered the deceased. So let's take the first issue. And the question is, did the first accused person know the deceased prior to her death? And this question has arisen because the evidence of the first accused person is, I did not know the deceased at all prior to her death. So let's analyze the evidence together. I have considered the prosecution evidence and the evidence of PW10, George Kimani, the brother of the deceased, is that he is known to the accused person because they were together at Kenya Polytechnic. As far back as, I think, 202, they were in the same class, taking the same course in hotel and beverage management. It is the evidence of that witness, please mark the date, on 31st of August 2018, he was with the first accused person in the house of the deceased. The death hearing was on allegedly unknown time, but it's said to be 19th of September. But I am saying, and I said, please mark the date. This witness, the brother of the deceased, says, prior to the death of my sister, on 31st of August 2018, I, my girlfriend, the first accused, and the deceased were in the deceased's house. Ramoria Gardens, same apartment. And that the sister, the deceased, mentioned to him that she was communicating with the first accused on Instagram. That on the material night, the first accused person and him slept on the sofa set, otherwise known as the couch, whereas the deceased and the brother's girlfriend slept. And I'm not saying this for no reason. Everything I say has a reason. Slept on the deceased bed. It is also the evidence of George Kimani. On 19th of September, the deceased sent him a screenshot of a conversation between her and the first accused. And that conversation was to this effect. The first accused was telling the deceased that when he returns from Mombasa, he would go and see George Kimani, that is the deceased brother, for a drink. And that the deceased was telling the first accused person, don't spoil my brother. 19th of September. My observation from the evidence is that this evidence of George Kimani, that on 31st of August 2018, he was in the deceased house with the first accused person, was not disputed through cross-examination of the witness by the first accused person. And I will tell you why. This was the nature of cross-examination by the first accused person. I quote, the deceased was communicating with Joey, but she didn't describe how they were. I believe they were friends. There is a night we spent with the first accused in the house of the deceased. We were all happy. I slept on the couch. I woke up in the morning. The first accused person had already gone. When I woke up, I was not very drunk. I wouldn't know what the first accused person did with my sister when I was asleep. I don't know whether he was another man in my sister's life. If he was, I would have known. I did not know Kako. And my analysis of this cross-examination does not lead to an accused person denying that I don't know the deceased. Further to this evidence, It is the prosecution case that there was a video retrieved from the first accused's cell phone, which was allegedly recorded by the first accused person, which shows that he was in the deceased house prior to her death. I did not have the benefit of that video. I must make it clear. But more importantly, and this evidence to the court was very important. Why am I saying it was very important? Because the evidence of George Kimani is evidence from a relative of the deceased. I treated the next evidence that I'm going to speak to as independent evidence to the question as to whether the first accused person knew the deceased prior to her death. This is the evidence of number 70110, Corporal Jonathan Limo, who testified as PW33. This is an officer tied to Safaricom law enforcement. He's a data analyst, and he said in his evidence that he analyzed data from a telephone number 0727 001675 registered in the name of the first accused person, Joseph Irungu Kuria. He also analyzed data from 2 cell phone numbers, 0727, 0704 170422, 0715 775856. Both of them were registered in the name of the deceased, Monica Kimani. It is the evidence of this witness that on 1st of September 2018, the number of the first accused person called the number of the deceased. And that call was made at DOD Langata, and it was an outgoing call. Based, therefore, on the evidence of George Kimani and the data analyst PW3, it is the finding of this court that the evidence by the first accused person that he did not know the deceased prior to her death is untenable, it is insincere, and it is an afterthought, and it is false. It is the finding of this court that the first accused person was known to the deceased prior to her death. Allow me to move to the next item. This next item is whether the first accused person stole an identity card of Dominic Bisera and used it to access Ramuria Gardens, where the murder took place, on the fateful night. I will be probably returning back to this evidence. You will get to know why, but let me speak to it now. Excuse me. Dominic Bisera Harun testified in this court. And his evidence was to the effect that on 17th of September 2018, he went to Royal Park Estate in Langata to look for casual work. The requirement at the main gate was that you leave your identity card at the gate. And so he left his ID card at the gate. And he was supposed to collect it in the evening after work. When he came to collect his ID card, he did not find it. The following day he went, he did not find his ID card. I am speaking to the events of 17th September 2018. And so, he left his contacts written in the book with the guards, the occurrence book, contacts, Dominic, telephone number, and said, turn into a bit of Kiswahili, mukipata hii kipande changu, tafadhali mnijulishe. I have had the benefit of that record. It is his evidence that he never got his ID at all. I have had the evidence of the witness who came from the Registrar of Persons who has confirmed to this court that Dominic Bisera Haron eventually got a duplicate ID in the year 2019. There is evidence from witnesses at Royal Park that is true Dominic lost his ID. There is evidence from Protected Witness 3A to the effect that the person who went to the deceased house on 19th of September 2018 produced an ID in the name of Dominic Bisera Haron. This witness identifies the first accused person on the parade as the Dominic Bisera Haron. I come to the parade. And so, at this stage, I find adequate evidence that the ID of Dominic Bisera Haron was stolen at Royal Park Estate in Langata on 17th of September, 2 days before 19th of September, when the offense was committed. I have made an observation that this ID was stolen from Royal Park Estate Langata, and it happens that the two accused persons were residing at Royal Estate Langata. As to whether the first accused person used this ID to access the Muria Gardens and commit a murder, hold it. The next question and issue I'm going to address